This lecture is the continuation of the previous lectures. As we are discussing regarding the national and international prosecution of the international crimes. So we have already discussed at the length regarding the national prosecution of the international crimes. So this is one thing is clear that students, what we are trying to understand in this scheme of course, how the states will react and prosecute the crimes which are the regarding the international perspective. So to anything, being a law student, it is clear that anything which we deal with, we need the certain sources of laws. Which are those laws? Which are contained in the shape of the enactments, statutes, treaties, conventions, and court decisions. Another source that is the customary practices. So now my next topic, which is regarding the customary, what are the customary obligations? Beyond the treaty obligation, genocide, crimes against humanity, and at least in part, war crimes are also criminalized in customary international law. As mentioned and discussed earlier, some national prosecutions have taken place, but these are rare and actual state practice does not support the position that states have a general duty to prosecute international crime. These are the not duty of the states. In a legal commentary, it has been suggested that a duty to prosecute or extradite, however, exists in customary international law. The duty would bind states regardless of whether they are parties to the relevant treaty or not. The claim is sometimes made by reference to a particular crime, but sometimes by reference to all international crimes. There are expressions in support of customary duty. The 96 International Law Commission draft Code of Crimes against the peace and security of the mankind. For example, advocated a duty to prosecute or extradite individuals accused of the genocide, crime against humanity, and war crimes, as defined in the code, and to prohibit such crimes regardless of where or by whom the crime was committed. The ISTY, International Court of the International Criminal Tribunal Yugoslavia Appeals Chamber in Blaskik has stated that there is a customary obligation to prosecute or extradite those who have allegedly committed grave breaches of the international humanitarian law, but without developing the argument further. As far as preamble of the International Court, ICC, International Criminal Court Statute, recalls the duty of every state to exercise its criminal jurisdiction over those responsible for international crimes, although without clarifying the jurisdictional scope of this duty or being reinforced by any operative provision in the statute. A strong case can be made, however, that such a duty is emerging concerning prosecutions based on their territoriality and perhaps nationality jurisdiction. Another line of the argument is that a duty to prosecute follows from the nature of the international crimes. The core crimes of the international criminal law rest on the norms of peremptory norms, which call isocogens, and as such give rise to obligation omens, which means towards the entire international community. The conclusion that what we understand is the duty of prosecute or extradite does not automatically resolve the scope of the criminal jurisdiction to be exercised by the states, in a particular third states. Students, further, the next topic, that is the domestic criminal law and criminal jurisdiction. First of all, to deal with the domestic criminal law and criminal jurisdiction, what are the domestic legislations? Of course, national prosecutions, we suppose that there is an applicable criminal law and criminal jurisdiction. The Genocide and Geneva Conventions explicitly requires that the states parties enact necessary legislation. Some states adopt implementing legislation, while others rely upon direct application of the international law in the domestic system. Therefore, not all states will need domestic legislation to meet their treaty obligations. A number of states have enacted special penal law on war crimes and genocide, either in a civil or military penal system or both. Prior to International Criminal Court statute, there was no generally accepted convention on crimes against humanity, and thus these crimes were only rarely provided for as distinct crimes in a domestic law. Such as aggression is criminalized in a minority of these states. Reliance upon ordinary crimes may fall short of the criminalization in the international law, and therefore the state may violate its duty to enact with the manifestation of the seriousness that is fixed in the international crimes. In Australia, the approach to rely on the ordinary crimes in meeting the obligations under the Genocide Convention led a domestic court to the conclusion that genocide was not recognized and could not be prosecuted. In some cases, the special legislation that is introduced is unsatisfactory, and even if the definition correspond to those international law, other aspects such as the modes of the liability set forth in the Genocide Convention are sometimes overlooked and inadequately addressed by the application of the ordinary domestic criminal law principles. Customary international law is rarely reflected. This will hinder prosecution of the crimes that are based on the international customs only. Some states, such as Germany, do not accept non-criminal law due to strict interpretation of the legality principle. Other states do accept such law, such as common law jurisdiction like the United Kingdom, and also direct application of the customary international law by the national courts. But not that customary international law is capable of creating offenses in the domestic law. The power to create new crimes should be reserved for the domestic process and elected assemblies. Furthermore, students, what is the role and is the International Criminal Court is a catalyst for the domestic legislation. The fundamental principle that the ICC is a assumed jurisdiction only when states fail to do so. The complementarity principle provides a strong incentive for states to enact the crimes laid down in the ICC statute and to greater or lesser extent assume jurisdiction over crimes committed abroad. Although not a legal obligation under the statute, states will want to meet the complementarity test. It is also an opportunity to express a commitment to combating impunity for the most abhorrent international crimes. And this has already led to new penal legislation being passed in a number of states, sometimes in spite of having been parties to the relevant conventions for a long time, and the process is underway in the others. The introduction of such laws is a complex task. However, and requires careful political and legal considerations when it is politically important to ensure criminalizations that agrees with that of the ICC, and therefore to prevent the ICC from intervening in future cases. The safest option is to adopt the offenses as defined in the ICC statute. As far as ICC is regarding my complete lecture, inshallah, after completing this section part of this course, my complete lecture I will deliver on the introduction, creation, jurisdiction, and role of the ICC. In that lecture, you will understand the how ICC will take intervene in the cases where domestic prosecution failed to do so. So, students, this is the approach taken by Australia, Canada, New Zealand, South Africa, and the United Kingdom. Another approach is to transform the offences into the normal legal terminology of the national system, as has been done, for example, in Germany. In this process, however, states must also take into account their other international obligations concerning international crimes. Accordingly, the German approach has been to focus on the customary international law offences. Yet another approach is to ensure that ordinary domestic offences cover all the conduct that also falls within the crimes of the statute. Neither the complementarity test nor the related nebis in idem provisions require that the state and the ICC make the same legal characterization of the underlying conduct. That national law also include genocide crimes against the immunity and war crimes as the specific offences, and relevant conduct is prosecuted as such. The rule of nebis in idem, which means the to prosecute or to extradite. It means that the state must take the action, illegal action against those offences which committed within the territoriality and nationality jurisdiction of the persons. Otherwise, to hand over the custody of that person to the state who is the victimized state, and that state will prosecute that person. So, in this regard, the next our topic, which is the what are the statutory limitations. Most domestic systems no statutory limitations or prescriptions, that is the time limitations on prosecution. While most civil law jurisdictions provide for a general application, most common law jurisdictions exclude murder and other serious crimes. Neither the post-Second World War trials nor the Geneva Convention or Genocide Convention address the issue, but subsequently there has been much debate regarding the application of the statutory limitation with respect to the genocide crimes against humanity and war crimes. Statutory limitations, the goal of that limitations are that prevent unjust delays between the commission of the offense and prosecution. But could, if applicable, lead to impunity for the most heinous international crimes. In order to close this possible technical escape from liability, treaties on the non-applicability of the statutory limitations to genocide, crimes against the humanity, and war crimes were adopted under the auspices of the United Nations and the Council of Europe. Some states have also passed laws which make statutory limitations inapplicable to such crimes, but these laws vary in scope. There is also some municipal and international case law to effect that statutory limitations shall not apply to international crimes. For example, ISTY ruling regarding the torture in Dija case. The ICC statute explicitly provides that statutory limitations do not apply. The enforced disappearances convention, although stopping short of the disapplying statute of the limitation for individual disappearances, provide that any limitation shall take into account the exceptional seriousness of the disappearances and shall only run from the end of the offense given its continuing nature. But the statute of the limitation have been obstacles in the national prosecutions. In the Barbie case, for example, the French law on non-application of such limitations was strictly interpreted to apply only to crimes against humanity, thus bearing prosecution for war crimes. Similarly, a prescription concerning war crimes also led to the acquittal by Italian courts in the Haas and Probicki case. where the accused had admitted to massacre of the hundred of civilians during the Second World War. Still, war crimes carrying life imprisonment under the Italian law were considered exempt from these statutory limitations. So, students, so these are the statutory limitation of the certain crimes and the state responsibility we have discussed in this part of topic. So after a few minutes, I will continue my this lecture. That will be the concluding part of our today's lecture. So